not only is the coverage of our subject matter quite complicated, like I told you, it keeps getting tougher and tougher. Second, we have joint classes, so it makes it very difficult to entertain questions or to require recitation, because it's very difficult to handle, by my count now, 74 people. And it should be more. It should be close to 100. Third, we have the pressure not only of our upcoming prelims for this subject, but your prelims in your other subjects as well. So I understand the pressure that is happening to you. I don't pity you for it, because all students go through it. And if you want to be a professional, you have to learn how to adjust to pressure and to handle multitasks. Okay, so today we will hold joint classes, both sections, from 2:30 to 5:30, which is 3 hours, which is our allocation for these next 2 days. Ngayon, kung maalala nyo, kaya natin ginagawa ito ay bukod sa pahirap ang ating tinatalakay, ay mas mainam rin na minsanan ko lang ipaliwanag ang mga ito, dahil nahalata ko na kung minsan may nababanggit ako sa isang klase na hindi ko nababanggit sa kabila. I'd like you to understand that although my field is not civil law, I have been a criminal lawyer for a long time, but because I'm a practicing lawyer, I'm familiar with almost all fields of law except tax and commercial law. I practiced a little bit maritime law, so I'm a bit familiar with that. I have done a good deal of labor law. So, ang ibig sabihin, a person in my position is able to explain these things, but it's not necessarily our field. So, I don't really follow the book nor have lecture notes per se. It's I'm really depending on what we call stock knowledge. My stock knowledge of these topics as I use them as a practicing lawyer. Okay? That's the advantage, I think, of having your instructor, your lecturer as a practicing lawyer, because we try to keep updated, although it is not necessarily our field. Alam niyo, kung bigyan niyo ako ng kaso ngayon sa labor, although I've handled so many labor cases, tonight I will study again, just to be sure. Ganyan talaga ang practicing lawyer. Okay. Class presidents, ganito ang gagawin natin ngayon. So it's 3 hours is too long, even for me. So, at we're supposed to end at 4. Siguro mga 3:30, 3:45, we will have a 15-minute break. And after the 15-minute break, before we start our next part of the session, mag-class picture na tayo. Class presidents, you still have to report to me who are absent, and I would appreciate it, because of the weather and things like that, kung yung mga nag-absent, please explain to your class presidents bakit kayo nag-absent, para hindi naman yung Excel na natanggap ko, walang explanation, I will consider you absent talaga. Okay? Now, some people do contact through the messenger board, so that's also good to explain their personal circumstances. I'm not putting a grade or no grade on attendance, but kung lagi kayong absent tapos bagsak pa kayo sa exam o semplang kayo sa exam, madali paliwanag kayo din kung bakit kayo babagsak. Diba? Ganun lang yung kasimple. Okay. So we will have an hour 15 minutes lecture, then we will rest, and then we will have another part of the lecture, and then maybe we'll give it 15 minutes rin. Kasi it makes no sense to rest at the end of the period. So 30-minute break. But we will consume the allocated hours to us. Okay? So ang coverage natin ngayong class, kung nakita niyo yung assignment, ay bagong topic. Kinds of obligations, pure, conditional, hanggang penal clause. Ngunit yung sa ating prelims, ang tatalakayin lang natin hanggang I think alternative obligations. Alternative or substitute obligations. So, i-text nyo na yung mga ibang classmates nyo na wala pa rito dahil malilate na sila. Ngayon, kung makikita nyo yung ipipresent ko ngayon, ang academic calendar. Kung makikita nyo, prelim exams ninyo sa ibang subjects nyo actually September 12 to 14, which is Monday, Tuesday, Wednesday. Tapos, ang last day for dropping ay September 16, napakalapit. Kaya ang aking hiling sana, yun ang sinabi ko sa message kanina sa ating group, ay kung maaari tayo mag-exam ng 14 o 15. Kung kailan kayo maluwag-luwag na, para yung mga palagay nila ay hindi maganda ang kanilang performance sa prelims kasi lalabas ko kaagad yung grades, ang makapag-desisyon na para mag-drop sa halip na lalong mapinsala at baka bumagsak pa. Now, there is no other gauge really for your performance other than the prelims. At yung inyong first reaction paper, isasama ko na yun sa prelims as an essay part of the exam. Okay? So, at least gumaang ng konti yung inyong prelims. Ang aking pakay sa prelims ay hindi upang talakayin lahat. I think mahirapan tayong gawing comprehensive ito dahil napakalawak dito. Sabi ko sa inyo, sa law school talagang matuturete kayo, kaaral lang hanggang dito sa topic na ito, hanggang alternative obligations. So I can imagine how difficult it is for business students. Kasi sa law students mahirap na. Okay? And we signed up for the difficulty. So I will be considerate. Tulad ng sinabi ko sa inyo noon, pag-aralan ninyo yung pag-solve ng problems. At kung merong ang ginagamit yung libro ay yung kay De Leon and De Leon, makikita niyo may sample problems, di ba? At may sample at may sagot sa likod. Okay? So, clue ko na yun sa inyo. Pag-aralan nyo yung sample questions sa De Leon, kasi kung hindi yun ang mismo itatanong ko, kung tamad ako at yun na lang gagamitin ko, malamang kapareho nun. Siyempre, hindi ako magiging tamad kasi nasa likod ng libro yung sagot eh. Diba? So hindi ko tatanungin yung mga tanong ni De Leon and De Leon. But, ganong style ang pagtanong ng problems. So, I suggest to you to study, to get a hold of the book before our exams and to study it. Now, I will tentatively set the exams, prelim exams for September 14. Evening. Paano naman to? Open box, open Google, open everything. Magsama kayo sa isang kwarto kung gusto nyo. O mag-Discord kayo tulad ng ginagawa ng klase ko last sem. It doesn't matter because it will be under time pressure. And like I told you, if it's the first time you encounter these issues, this is the first time you see a problem like the ones that are depicted in De Leon's sample questions, if this is your first time to study, you will run out of time. And when you run out of time, and you just guess, hindi 50-50 ang chance doon. It's probably 20-80. Because I can tell when you're guessing. Okay. I promise to be lenient, but please don't disappoint me. So unless you, obviously you cannot react to me now because we're running out of time. I will accept comments on this later during our break or in our message board for message group so that you can tell me your. But I do not see any problem with setting it after all of your prelims. I'll set it in the evening. Kung gusto niyo, alas 10. Bahala kayo. To give you time to review. Yung mga absent ngayon at nung ibang araw, magpaliwanag na lang kayo, magbigay kayo ng paliwanag sa message group natin at saka sa presidente nyo. Kasi sila yung gumagawa ng attendance sheet. If you have technical problems, I'll take your word that you have technical problems. Bahala kayo. Ang epekto lang ay you are also responsible for asking your classmates about what was discussed and going over the same in the textbook. Now, I don't use De Leon and De Leon in preparing for this class, but I do look at it just before we start. And maganda, De Leon and De Leon has improved since we used it when I last looked at it in law school. Back then it was too simple. It is quite simple, but it's good enough for you. It's a very good discussion. Some of the examples are not very good, so please listen up. Okay. This is our topic for today. Now, if you'll notice, it's quite extensive, Kasi babalikan ko yung pinag-usapan natin ng huli, tapos matatapos tayo sa obligations to the penal clause, which is the end of the chapter on kinds of obligations. Ngayon, itong ibang parte, part 5 and part 6. Siguro kahit part 4, hindi ko pa naman ginagawa yung part 3. Hindi ko pa naman ginagawa yung exam. Madali lang yung alternative facultative obligations. Yung joint and solidary, medyo masalimuot yan. So, divisible, indivisible, at saka yung obligations sa penal clause is very simple. Yung joint and solidary obligations, indivisible obligations, medyo masalimuot yan. So I will just let you read it for tomorrow. I will take it up as the first part of our first lecture after the prelims. The reason why I want to give special attention to this and not rush it today, even if we have time, is because joint and solidary obligations are very, very common in contracts. And you as practicing accountants or as business people will certainly encounter joint solidary obligations, divisible, indivisible obligations, in obligations with the penal clause. Definitely. The other topics that we although there are really obligations with these types of characteristics, knowing them is theoretical because even if you don't know them, all you have to do is tingnan ko yung mga notes ko kay Attorney Balanag, I'm sure maintindihan ko yan. Diba? Or just read De Leon and De Leon again. Okay. From the last lecture, we spoke about fortuitous event, and we said that no party is obliged to be liable for the happening of a fortuitous event during the fulfillment of the obligation or the non-fulfillment of the obligation due to a fortuitous event. But we have the principle of assumption of risk. And this is also important for you when you're already in business. I gave you the example last time. May mga talagang obligations where the obligor undertakes the risk of fortuitous events. Marami yan eh. I don't need to list them down. I'll just give you a few examples. The easiest is the one I gave you last time, yung hotel-motel. Pag pumunta ka sa hotel at motel, it is really in the law. It is an assumption of risk required by the law that the hotel keeper, the innkeeper, yan ang term na ginagamit, innkeeper. So, type natin yan dito Yan ang example na ibibigay sa inyo. Innkeeper. The innkeeper is a depositary. In other words, siya may hawak ng mga bagay na iniwan sa kanyang hotel. Sa kanyang inn. Inn yung unang panahon, inn ang tawag dyan. Wala na, ewan ko kung may mga inn pa ba ngayon. Motel at hotel na lang, at saka resort. Diba? Yung resort, hotel naman talaga yan. So that, if you keep something in the safe, kahit actually sa kwarto iniwan sa kwarto, iniwan sa lobby, liability yan ng hotel. Kung iniwan mo yung kotse mo sa garahe nila, kasi hindi ka naman pwedeng pumunta sa hotel, wala kang dalang sasakyan, at yan ay naanod dahil sa baha. Baha is a fortuitous event. They're still liable. Kasi, ang iniisip ng batas, ikaw naman pumili ng lugar ng iyong inn, ng iyong hotel, yung iyong motel, yung iyong resort. So, dapat pinili mo yung lugar na safe from baha, at kung sakaling may earthquake, ay hindi naman mapipinsala yung mga kasangkapan dyan. So, ganun ang tingin ng batas. Kaya, the innkeeper is required to assume risks, including the risk of fortuitous event. But otherwise, hindi. So, yun yung principle of assumption of risk. Makikita nyo yan pag kayo ay naging nasa loob ng business ng pag-hotel, nasa business kayo ng pagsasakay ng pasahero. The contract of carriage. So, ilagay natin yan. Contract of carriage is a contract of the bus owner and the passenger, the jeepney operator and the passenger, the train operator and the passenger, the airplane company and the passenger. And the passenger's goods. Yung bagahe nyo. Sumakay kayo sa Cathay Pacific. Magandang airline yan. I personally like Cathay Pacific. Except for the fact na that it's a Chinese carrier. Sarap pagkain, kahit economy ka lang, ganda service nila, very good planes, very new planes, very competent pilots kasi they don't get Chinese pilots, they get international pilots. Ewan ko lang ngayon. I haven't ridden Cathay Pacific in a long time. Pag nawala na yung bagahe nila, sasagutin nila yun. Kung na-late yung aeroplano mo, halimbawa, na-delay dahil nawala, that happened to me one time. I flew China Airlines. China Airlines is Taiwan. Not People's Republic of China. So I was flying to my conference in The Hague, Netherlands, for the government, and the plane lost one engine. It had 4 engines, but it lost one engine before getting to Dubai. So we had to lay over in Dubai because although the plane can fly with 3 engines, the operator who has assumption of risk hindi pwedeng mag-take ng chance na, kung mawala pa yung 2 engines, isa pang engine yan, delikado na, 2 engine na lang yung aeroplano. Sa Boeing 747, super jumbo. So, nag-land siya sa Taiwan, sa Dubai. It was really scheduled landing. Ngunit ang nangyari dyan, sinabihan kami ng management na, we cannot fly, we have to fix the remaining engine, it will take 1 day. Tinotel kami. We went to hotel, we had buffet meals, and then kinuha kami mula sa hotel ng ayos na yung aeroplano. Of course, Dubai is very hot, so there's nothing else to do but stay in the hotel. So yun ang contract of carriage. when you have when a company, usually a company, or an operator of a jeepney, pwedeng yung operator kasi isang tao lang, undertakes the contract of carriage, pagdadala sa tao at bagabagahe, there is an assumption of risk because it's in the law. Ngayon, tingnan nyo, ladies and gentlemen, yung Article 1176. Anong nakalagay dyan? When a debtor, excuse me, the receipt of the principal by the debtor without reservation to the interest shall give rise to the presumption that said interest has been paid. Ganito kasi yan, ano? And the receipt of a later installment of a debt without reservation as to prior installments shall likewise raise the presumption that such installments have been made. These are what are called legal presumptions. Na? Legal presumption ang 1176. So isusulat natin yan. Ha? Dito kasi ang obligasyon. Pag ikaw ay nagpahiram ng pera at ito ay nag-earn ng interest, ang nangyayari dyan, usually, later on, ano, when we study contracts, makikita nyo, the way it works is you pay the interest first before you pay the principal. Why is this? Because akong nagpapahiram ng pera, ang aking kita talaga doon sa interest. The interest that I charge you as the borrower represents my cost of money. In other words, how much I am also paying somebody else, like a bank or some other institution, to have lent you to have that money. No? Halimbawa, pinahiram ko kayo 1 million. Yung 1 million, kinuha ko yun sa ibang lugar. Diba? So, nagbabayad rin ako interest doon. So, that covers that, my cost of business, as well as my profit. And where do you see this, ladies and gentlemen? Very, very vividly in the credit card. Because the credit card has the highest interest charge by a legal contract. The interest charge on the credit card used to run as much as 36 to 40 plus 45% a year, which is really usurious. You know the term usurious? It's usury is to be punished, but there is no usury now. There is no usury law. The usury law has been repealed. But usury is a concept in the Bible and in the Muslim Quran. It is a religious concept. It is the concept that you should not charge so much for lending out money because you are imposing a burden on the borrower. So an interest rate charged by the credit cards of 36 to 45% a year is very, very large. It is almost usurious, but it is legal. Bakit gano'n ang credit card? Kasi ang credit card, nagpapahiram kahit sino. Diba? You try borrowing 1,000 pesos from the bank. Unless meron kang collateral, meron kang letter of guarantee, maganda yung iyong trabaho, maganda yung income mo, tapos meron kang properties, meron kang credit history, nakita ka na humiram noon at nakapagbayad ka na, hindi ka makakahiram sa bangko kahit isang kusing. Because they don't know you. Why will they take the chance with you? Why will they lend to Joseph Balanak? Eh meron naman diyang Ramon Ang, di ba? O meron naman diyang Andro Tan. O meron naman diyang Edwin Uy na mga bilyonaryo. Doon na lang ako magpera ng pera, sigurado pa ako mababayaran. Diba? Ganon ang bangko. But the credit card, no. Nahalata niyo ba ito pagpunta niyo sa mall, pagpunta niyo sa, kahit sa kanto lang dyan, pagpasok niyo ng parking o ng bus terminal, meron nag-offer lagi din ng credit card. The credit card kasi they're willing to give it to anybody who has a salary. Tapos, iniinganyo kayong humiram ng humiram. The credit card is a credit. Di ba? Hiram kayo dyan eh. May nakita kayong cellphone. May nakita kayong mura lang nakuha na item sa Miniso. Sa halip na magbayad kayo ng cash, kahit 200 pesos lang yan, pagbayaran yung credit card. Pagbayaran nyo at the end of the month, wala kayong surcharge. But ang mga tao kasi, they do what is called revolving credit. There are revolvers, you know? You should be familiar with these terms if you will have jobs, ha? Revolver. Hindi ito yung baril, ha? Yung 200 na hiniram nyo, pwede nyo yung utangin. So, i-installment yan. Sa halip na magbayad kayo next month ng 200, charge na lang kayo ng 25. I-break nila yan throughout the year. Yung 25 na yan, it includes principal and interest. So, ano ang principal mo dyan? 200. Kasi yun yung binili mo sa Miniso. Wait, yung babayaran mo sa credit card, hindi yung 200. Plus, 36% interest every year. Diba? So, ikukuhan rin nila yan, i-breakdown rin nila yan. So, ang mabayaran mo lang, pagkatapos mong binili yung item sa Miniso, ang babayaran mo sa next payment period sa credit card, siguro mga 50 pesos and 45 centavos, magaang na, di ba? So, madaling bayaran. Yan ang pang-entice ng credit card. Parang napakagaang magbayad, di ba? Ang sarap bumili kasi next month, magkano lang, bumili ka ng you can buy an appliance and just pay it in installments, di ba? Napakadali. Kung bibili mo ng installment yan at dadaan ka sa appliance store, kailangan mo pa magkaroon ng credit check sa bangko. Mahirap pagkaroon ng approval mo sa bangko unless maganda talaga ang credit history mo at maganda ang salary history mo. Eh kung starting employee ka lang, diba? Basic salary ka lang, ang sarap ng credit card. But that is the stinger. Because the credit card company, yung binabayad mong 50 pesos, 25 pesos, 100 pesos, maliit lang na bagay every month, hindi yan yung principal. That's only the interest. They will collect the 36% interest first before letting you pay for the principal. So ito yung 1176. I'm sorry, I dropped something. When you pay a debt, you should pay the interest. The creditor wants you to pay the interest first and then the principal. So if you borrowed 1 peso and there's an interest of 20%, when you pay that, that's 1 peso and 20 centavos. Kaya si creditor, nakita mo, ikaw yung debtor. Binayaran mo siya ng 1 peso. Sabi niya, oy, attorney, buti nakita kayo, babayaran ko na yung utang sa inyo. Ito yung 1 peso, inutang ko sa inyo. Pag tinanggap ko yan, under 1176, the law presumes that bayad na yung interest. Kasi kung ako yung creditor, bakit ko tatanggapin yung principal kung hindi pa ako bayad sa interest? Yan ang ibig sabihin niya. Kaya mag-ingat kayo. Pag kayo ngayon, ang auditor, kayo ngayon ang controller, kayo ang accountant ng isang kumpanya o kayo ang in charge sa finances ng inyong business. Or kahit sa sarili niyong personal na buhay. The obligation to pay presumes the obligation to pay principal and interest. Yan ang ibig sabihin ng 1176. I'm sorry, I was not showing the right. So you can see that, the terms that we have been using. legal presumptions, usury, and now we're talking about revolver. So 1176 is a caveat, it's a warning to those who are accepting payment and who are making payment. Ganun rin ang rent. Umuupa kayo halimbawa sa apartment. Pag kayo ay nagbayad, ang gagawin ng inyong lessor, bibigyan kayo ng resibo para sa huling buwan na hindi kayo nagbayad. So halimbawa, 3 months in arrears na kayo. June, July, August, hindi kayo nakapagbayad ng upa. Nakapagbayad kayo ngayong September. Pumunta kayo sa inyong lessor. Sabi nyo, Madam, magbabayad daw kami ng upa. Ito yung upa. Halimbawa, ang upa 1,000 bawat buwan. So nagbayad ka na ng bayad ka 1,000. Sasabihin ngayon ni lessor, itong bayad na to, hindi to sa September. Kasi July, June, hindi ka nagbayad. July at August, hindi ka pa rin bayad. So ito pag-aaralan natin later on. Please remember this term, application of payments. This is application of payments. I will apply your payment not to September when you actually paid me, but to June. Kasi June yung huling buwan na hindi ka nagbayad. Ngayon, kung tinanggap ko yung September, ibig sabihin, okay na ako sa June, July, August. Huwag nyo lalamangan niya yung lessor, baka naman ulyanin lang siya. But that is the presumption. You must remember, this is only a presumption. A presumption means, in the ordinary course of things, we can conclude that if a person accepts a payment, he has condoned previous payments. That is a presumption, but it may be a presumption can be overturned. A legal presumption can be overturned. Ano yan? Di ba nag-aapura kasi si landlady? Nag-aapura siya kasi susundin niya yung kanyang anak, umuulan. Nag-aapura siya. Tinanggap niya lang yung payment mo. Mama, magbabayad daw ako. Ito yung bayad ko, 1 buwan. Sige na. Tapos later on, sabihin mo, halimbawa, October na, magbabayad ka ulit. Sabihin mo, Ma'am, ito yung bayad ko, October, upa. Tapos sabihin ni landlady, hindi ka naman nagbayad. Yung binayad mo ulit, June yun. Kasi hindi ka bayad June, July, August. September, hindi ka rin bayad. So, nagbayad ka ngayong October, hindi yan October, hindi rin yan September, yan ay July. Sinong tama dito? Pwedeng sabihin kasi ng landlady, hindi niya tinanggap niya lang yung payment, but hindi niya tinatanggap na yun ay kabayaran ng September kung kailan niya natanggap. Because she is overturning the presumption that acceptance of a lease rental today presumes that the previous lease rentals have been paid. Dahil at that time, hindi naman niya sinabing, sige, okay na to, September ito. At nagbigay siya ng resibo September. Diba? That is the overturning of the presumption. So although may nangyayari yan, there is application of payment when you pay for when you pay something and it is charged to an obligation you had outstanding. Ano pa example nitong presumption of payment? Yung sa Meralco. Nangyari ito sa akin. When you don't pay sa Meralco, they will, and you pay again. Nangyari ito sa akin kasi this was the time yung they condoned, yung pandemic, nag-condone sila ng payments. Tapos sinabi nila installment na lang yan. So ang nangyari dyan, nagkagulo-gulo kami sa accounts namin, not being an accountant, unlike you people when you finally pass the board exams. Ako naman, I just assumed that we already paid the installment, so we paid regularly. What the Meralco was doing pala was applying our payments to the installments. Kasi mali ang aking calculation. So I ended up 10,000 pesos short. So nagalit ako, pumunta ako sa Meralco, dala-dala ko yung aking folder. It turns out I was wrong because Meralco had implemented application of payments. They had implemented, they knew about 1174, 1176, presumptive full payment. They did not want to be presumed of that I had paid fully, so that's why they were only crediting my payments to previous payments because I didn't know that I had arrears. Right? It wasn't clear in their billing that I had arrears. Hindi kasi nilalagay doon, unpaid installment, doon nila linagay yung payment. So, medyo kasalanan rin nila yan. But anyway, my classmate is the legal counsel of Meralco. I will complain to him one time. Not my classmate, my underclassman. Okay. We now enter a new chapter, which is the various classifications of obligations. And I want you to pay close attention to these classifications, much as they seem to be very technical and confusing, because they will help you in analyzing real-world problems. Ano? Why do we have all of this pure, conditional? Tingnan niyo yung aking lecture notes ngayon. Pure, conditional, suspensive or resolutory conditions, mixed conditional, possible, impossible conditions, express, implied condition, conditions with a period, alternative or facultative obligation. Bakit may ganyan? Because you remember, the Constitution guarantees the freedom to contract. And when the parties contract, they can impose upon each other any terms or conditions that they see fit, depending on what they want to happen. That is the freedom of choice, the freedom of the parties to contract. So all of these examples that we're going to be studying through the evolution of contract law are the permutations and the alternatives and the features allowed by the law to parties so that they can legally contract with each other. Please remember, class, parties have the freedom to contract in our capitalist system. And the contract between the parties is law. They have to comply with it. So if we have a condition, that means that something has to happen before an obligation can be complied with, or while an obligation is being complied with and it has to end, or it has a term or a period. The word term and period are the same. Kaya makikita nyo sa kontrata, di ba? The parties bind themselves to the following terms and conditions. Yung term dyan, kung sakaling may period doon sa contract. Yung condition dyan, kung sakaling conditional obligation ang pinag-usapan sa contract. Okay? So you have to know this because every contract will certainly have one, two, or a mixture of all of these features. And you have to be able to understand so that you know what is the legal effect and you understand whether or not a party complied. And because you will one day become accountants, controllers, auditors, finance officers of a company, or even owners of your own businesses, you have to know when to pay and when not to pay. Di ba? Yun ang importante. That is why we're studying oblicon. Para alam nyo kung kailan kayo dapat magbayad at hindi magbayad. Because let's go first. Conditional obligations. If an obligation is pure, walang problema. I will pay, X will give Y a horse. Very simple. So X should give Y a horse. Please note, when we study these characteristics of obligations, hindi pa tayo nag-usap ng contract law. Okay? These are only the obligation part of contracts. Because there are many other aspects of contracts that we do not take up here. The statute of frauds. When should the contract be written or not? When is a real estate contract, a contract involving real rights, when should it be registered? When should it be annotated? Iba pa yon. We will take that up later in this semester. So don't worry. We will go over those. These are just the obligations. So a simple obligation. X will give his horse, he only has one horse, to Y. Pure obligation. Make it conditional. Yung conditional, dalawa yan eh. Suspensive and resolutory. Suspensive means walang obligasyon until may mangyari. There's a certain condition that has to occur. X will give Y his horse if Y passes the CPA board exams. Diba? So what is the condition? Passing the CPA board exams. Why is it suspensive? Wala pang obligasyon. Wala pa. Halimbawa, ako si X, ikaw si Y. Next month, lumapit ka sa akin. Attorney naman, tumatanda na yung kabayo, ayaw na nakikita ko sa bakuran niyo. Kunin ko na. Bibigay mo naman sa akin, di ba? Can he do that? Can you do that? You cannot. Because the suspensive condition has not yet been complied with. It has not yet occurred. You have to pass the board exams. When you do, the obligation is demandable. Okay, suspensive. Resolutory. X will give Y his only horse. But if he does not pass the board exams, he has to give it back. Example dito, car. Tingnan nyo yung board natin. Pareho rin yan. Resolutory dahil pagkasabi ni X, I will give the horse, or in my example here, X will give his car to his son Y, he has to do it right away. It is immediately demandable. But it is subject to a resolutory condition. A condition in the future. That if he fails the CPA board exam, he has to give it back. Parang punishment, di ba? Yeah, alam mo, gusto mo ibigay yung kotse para madali ang pag-aaral ng ni Y. Kaso, kung pabaya naman si Y, absent sa klase ni Attorney Balanag o lagi bumabagsak sa exam, babagsak yan sa URS. Hindi lang yon, kahit ipasa siya ng URS, babagsak yan sa board exam. He has to return the car. If Y passes the board exams, the resolutory condition has never occurred. He can keep the car. Or he can sell it because he already owns it. Diba? But if he fails the board exam, the resolutory condition occurred and he has to give it back. Yung gano'n lang kasimple yung suspensive and resolutory conditions, but in the prelims, it will not be these examples or the examples given by De Leon and De Leon. So please, allow me to be creative. Okay, meron bang okay, thank you, Ms. Gaspar. Yung mga may legitimate excuses, just course it to your president. I'll take it up after the class. Now, the law also, again, ito yung mga presumptions. There is the principle of constructive fulfillment of a suspensive condition. And please look at 1186. So we will look at 1186. Oop, not one. 1186. The condition, whatever it is, whether it's resolutory or suspensive, shall be deemed fulfilled when the obliger voluntary prevents its fulfillment. Siyempre, kung ikaw yung obliger tapos ayaw mo mangyari yung condition, siyempre hindi ka mag-fulfill ng yung obligation, mali yun. Because that's cheating. Please look at 1185. The law also presumes that the obligation has been complied with when it is resolutory. The condition that some event will not happen at the determinate time shall render the obligation effective from the moment the time indicated has elapsed or it will not occur. X will give Y his only car if what's a good example? The Philippines wins a gold medal in the coming Paris Olympics. Okay? So that's a valid obligation. X will give his car to Y. He only has one car, so that's the car is going to give to Y. If not happen. I cannot give an example for 1185. I suggest. Okay. But that is an example of a legal presumption of the law allows the obligation to be fulfilled even if the event has not occurred because it will not occur. So, I'm sorry, I cannot give I'll get back to that. I'll give you a better example, okay, of that principle. Because we have to backtrack now and look at 1182. Oh boy, I have a bee inside my room. In 1182, we have the situation where the condition depends on the sole will of the debtor. So, for example, X will give his only car to Y if Y will go home to his to visit his mother at his other ancestral home. So si X kasi nanonotice niya si Y hindi dumadalaw sa nanay, tumatanda na. So sinabi niya, alam mo, umuwi ka lang. Tingnan mo yung nanay mo. Bibigyan kita ng kotse. No? Ngayon, kung si Y talagang gusto magkaroon ng kotse, gagawin niya yon, di ba? Ngayon, kung si Y ayaw niya makita yung nanay niya kasi may away sila, hindi niya gagawin. But the fulfillment of the obligation depends on the debtor because the debtor is the one who has to comply with the obligation. So that means that the obligation itself is void. It is ito kasi ang inisip ng batas. The law presumes that people go into obligations, go into contracts because it is mutually beneficial. In other words, tingnan natin yung situation ni X and Y kanina. Ang gusto ni X, dumalaw si Y sa nanay niya, makipag-reconcile uwi sa probinsya, makipag-reconcile, ayusin nila yung sitwasyon nila sa pamilya. Siguro si X, nagmamalasakit. So sa kanya, yun ang kanyang, that's the reason why he's willing to give his car, just to have that happen, para maayos yung problema sa pamilya. Siguro is also a relative. Maybe it's the older brother. Whatever, ano? So that is a valid obligation on his part. Is it a valid obligation also on the part of the Y? To see to it that the obligation is complied with. Maybe it is, maybe it isn't. The problem is that there seems to be no meeting of the minds, because Y has now the choice to comply with the obligation or not solely upon his own will. Ano? So, the law presumes that that is a void obligation. Because there is no obligatoriness, di ba? It depends on the obligee. In this case, it is two obligations. X will give a car to Y if Y will do a certain thing. But Y's, the condition that Y do a certain thing, which is to go home, reconcile with his mother, is all up to him. The law presumes that that is not a valid obligation. There is no reciprocity. Because although Y is very capable of complying with, X is very capable of giving his car, Y, you don't know what his obligation really is. It's really up to him. Whether or not he wants to reconcile with his mother, or to go home, or he maybe doesn't want to go home, or just wants to laze around the house. You know? So that is that conditional obligation. That obligation itself is void. However, if it depends upon chance or upon the will of a third person, it is valid. So if it is not, ito lang ang simple dito sa 1182. If it depends upon the will of the debtor, the person who will have to do the obligation, the obligation is void. Please contrast this with 1180. So I will now highlight 1180. When the debtor obliges him to pay, when his means permit him to do so, that is not a condition. The law says that that is an obligation with a period. So halimbawa, umutang ako, si X, umutang kay Y. Sabi ni X, umutang siya kay Y ng 1,000 piso. Sinabi niya kay X, bossing, X, Y, babayaran, sabi ni X sa kay Y, bossing Y, babayaran ko tong 1,000 pesos pag may pera na ako. That is not a condition. No, that is and that neither is it depending on his will. Kasi kung may pera talaga siya, kailangan magbayad siya. Diba? It does not depend on his will. He has to pay when he has money. It is deemed a obligation with a period. In other words, either the parties can agree on a period, which is called a contractual period. Okay, a period set by the parties in the contract, or it's the courts. Itang mahirap. Sabihin ko na sa inyo, we will encounter a lot of provisions like this. Ito ang mahirap sa civil code natin. Many of the provisions for enforcement require judicial enforcement. So ito yung isa sa mga yon. When the obligation presumes a period and the parties do not, we will take this up later also in one of the provisions on obligations with the period. When the parties intended a period but they did not set it, the period will be determined based on what they may have intended, which is very vague. You know? I don't know why the civil code says that, or if it is set by the court. Yun ang mahirap. Pag kayo ay may kontrata at ang pinag-uusapan nyo talaga, X and Y, ang gusto talaga nila mangyari, may period, at hindi nila sinet yung period, yung vagueness na yan, iaakit pa yan sa korte. Can you imagine the difficulty of hiring a lawyer and going to court, paying court fees? Alam na kasi, pag mag-file kayo ng civil case, kasi naghahabol kayo, meron yan tawag na docket fee. Meron yan tawag na legal research fee. Hindi libre mag-file ng kaso sa korte. Kaya alam nyo, hindi ko rin kayo mapagbibintangan kung sabihin nyo ang sistema natin ng batas ay para lang sa taong may pera. Totoo yun, unfortunately. Because when you allow the courts to be the ones to determine the period or to determine if the parties have complied with their reciprocal obligations, which will also take up later on, sakit sa ulo yun. You have to hire a lawyer. Magbabayad ka acceptance fee. Malaki acceptance fee ng magaling na lawyer. Diba? May appearance fee pa yan. May documentation fee pa yan. Tapos pag mag-meeting kayo sa restaurant, pakakainin nyo ako. Malakas ako kumain. Paano yun? Diba? Yun ang mahirap doon. This is the weakness of the Civil Code, 1180. When the parties do not decide on a period, and a period was intended, the courts will have to be the one to set the period. When the parties are in a reciprocal obligation, and most contracts are really reciprocal, and one party does not comply with his undertaking under the reciprocal obligation, and there is no provision in the contract for mutual rescission or rescission by one party, the courts will have to be the one to determine rescission. Nandiyan rin yan, later on we'll study that. Yun ang mali dito sa Civil Code. Because when you go to court, talo ka na. Unless you're fighting for billions of pesos, paying a lawyer and going to court is going to be expensive. What is the lesson, ladies and gentlemen? Make sure that when you write your contracts, you write it very well, so that there is no vagueness as to the period, there is no vagueness as to the condition, there is no vagueness as to the rights of the parties to rescind or to impose penalties. Yan yung obligations with the penal clause later on sa end ng ating session. Okay? Now, I'd like you to study 1181 on your own, because 1181 is very it is very relativistic. It depends really on the event and the type of condition. So De Leon has a very good matrix to show you what are the rights acquired and not acquired or lost, depending on the condition, whether it is suspensive or resolutory. My objective today is to lay out to you the important provisions and for you to just explain or to see how these provisions apply, lalo na yung 1182. Wala pa rin ako maisip na sole will of the debtor unless I look at my book, which is more comprehensive. So let's just go to 1183. Impossible conditions render the obligation void. Okay, so impossible conditions, ito ang kailangan nyo maalala, this will keep going, this will keep ringing in your ears henceforth throughout contract law. Conditions which are impossible, contrary to good customs or public policy, or prohibited by law are void. Void ang obligation that states them. Okay? What is you can think of an impossible condition, di ba? Like for example, mawala ang corruption sa Pilipinas. That's all. If you have a condition, I will give X will give Y 1 million pesos once corruption ends in the Philippine government. Oh, that's obviously impossible. Ano? So, ibig sabihin yung dalawang parties na yan, naglolokohan lang sila. Good customs. wala pang marriage between persons of the same gender, no? Actually, when we talk about gender, we're really talking about sex. There's a difference between sex and gender. I also wrote several gender and gender codes, you know, and there's a difference. Gender is just a pronoun. Sex is what you're born with, you know, what instruments a person is born with. So a person is either born man or woman, and despite what science would say that there are intermediate sexes, that is the legal presumption. So when you have an agreement that involves, let's say, marriage between two people of the same gender or sex, actually the same sex, that is contrary to good custom, because the custom still is that only a man and a woman can get married. It's not just a custom, it's actually the law. So please remember these terms. Because this is a term that will come back to you from time to time in contract law. Impossible conditions. Those which are contrary to good customs and public policy, and those prohibited by law. There is no valid obligation. So ganito yan. Gambling is prohibited by law. So halimbawa si X at si Y, habang nagiinuman, nagkuhan sila, oy, kumanalo bukas ang Boston Celtics sa laro nila. Babayaran kita ng 10,000 piso. Kung matalo sila, babayaran mo ako ng 5,000 piso. May partida si X kay Y kasi sigurado siya na mananalo ang Celtics. So he's willing to accept 5,000 from Y kasi sigurado siya mananalo. At bilang partida, kung manalo si Y, manalo yung inakala niyang hindi manangyari at matatalo ang Celtics, bibigyan ng 10,000. Whether nanalo or natalo, pwede mangolekta si X o si Y. In a court of law, hindi. Because it is law, gambling is prohibited by law. And any contract involving gambling or collecting on gambling debt, or halimbawa, X and Y say, pag matanggap ko yung aking shipment ng shabu sa Wednesday, bibigyan kita ng partida, tumahimik ka lang, bibigyan kita 100,000. Kasi yung shipment ko ng shabu ay halagang 10 million. Again, that is a void obligation because it refers to a transaction which is prohibited by law. Definitely dealing with drugs is against the law. The public policy is one of competition. Ano? Open, free competition. Capitalist tayo eh. If ABS-CBN and Villar's new TV station, I don't know what he calls it, he took over the frequencies of ABS-CBN when ABS-CBN was denied its franchise, which I think was very unfair because ABS-CBN has no obligations to the government, and in fact is one of the biggest taxpayers in Philippine society. And I'm not saying this because I used to lawyer for ABS-CBN. I state this because it's a fact. But halimbawa, ABS-CBN and Villar's TV station agree that ABS-CBN will only run comedy shows and Villar's TV station will only run Korean dramas so that they will not compete with each other's programming. You know? Hindi magsho-show ang ABS-CBN ng Korean dramas sa Villar TV station lang yan. Si Villar naman hindi siya magsho-show ng comedies, sa ABS-CBN lang yan. Is that a valid obligation or is that a valid condition? We will We will both run TV stations as long as you don't run comedies and the other will not run Korean telenovelas. That is not valid. That is not a valid obligation. That is not a valid condition because this is contrary to public policy. The policy is competition. Hindi kayo pwede mag-usap-usapan dyan at isa hawak niya lahat ng comedy, isa hawak niya lahat ng Korean telenovelas para hindi sila magko-compete. Hindi pwede yan. Kung meron kayong telenovela, ilabas nyo. Kung meron kayong comedy, ilabas nyo. Hindi pwede mag-usap kayo tapos you will manipulate the market so that you will have a monopoly on comedies and another one will have a monopoly on Korean K-novela, K-series. Mali yun. Okay? So that is contrary to public policy because the public policy is one of open competition. So yun ang example na mabigay ko dito. When a condition is impossible, it becomes a pure obligation. So not to do an impossible thing shall be considered shall be considered as a pure obligation. So not to do an impossible thing. So I will go to the moon. I will give you X will give Y 1 million pesos once X goes to the moon. Obviously, will not go to the moon. Okay, will not go to the moon. So that's an impossible. Not to do an impossible thing. It will just be a pure obligation. X will give Y. Okay. So please note, 1184 and 1185 relate to suspensive and resolutory conditions. So you should be able to apply a suspensive and resolutory condition and know the effects as stated in these provisions. Likewise, when you look at please at 1189 and 1190, these are specific to obligations which are suspensive and resolutory. Okay, so please just look at the conditions which apply to those because I want to focus now on reciprocal obligations. I'll just have a cup of coffee, okay? We will stop at 3:45. Continue at 4:15. But we'll have a class picture before we break, okay? Precedents. A reciprocal obligation is an obligation which is mutual. So usually, the most reciprocal obligation is really a sale. X has money and Y has an item. X will give money to Y only if Y is willing to part with the item. So that X will not give the money unless Y will give the item. And Y will not give the item unless X is giving him the correct amount. So it is reciprocal because there are now expectations. X, the buyer, expects the item to meet the quality expectations or the quantity expectations that he has. For example, X wants to buy a painting from Y. So it has to be a certain painting that meets his expectations. So they obviously in making the contract, the parties should discuss what exactly is the item being bought. It must be determined. Is this a painting that can be bought from many other, in other words, is it a generic painting? Because X has a gallery and there are many paintings there, and Y has a gallery and he has many paintings, and X is willing to buy any of those paintings. Or is X only interested in a certain painting, let's say in an Amor Solo or in a Hidalgo, which are masters, classics in Philippine painting. So he's willing to pay a very large amount of money for the original Hidalgo or for original Amor Solo. Likewise naman, si Y will not sell the painting for anything less than what he expects the painting to go for. So when you look at 1191, it's very deceptive. It is really this 1191. If you look at your screen now, and if you look at your book, is one of the most deceptive provisions in the Civil Code. It begins by saying that the power to rescind obligations is implied in reciprocal ones, in case one of the obligers should not comply with that which is incumbent upon him. The seller of the painting will certainly not give the painting if the buyer does not give the amount of money that he wants. And the buyer will certainly not pay the amount of money that the seller wants if it is not the painting that he wanted to have in the first place. So if you look at 1191, if one or the other does not comply with the obligation, it seems that one party has the right to rescind. In other words, ibabaliwala yung obligasyon niya. So the seller, the buyer, will not pay if the seller is not willing to sell or does not have the painting that he wants. Halimbawa, ang sinabi niya ay, gusto kong bilhin niya yung painting ni Hidalgo na yan, yung may barrio scene, may barrio fiesta scene. Yan lang. Now, even if Hidalgo has several other paintings that have that barrio scene, by the mere fact, remember we talked about this, this is now a determinate object. It is the only painting of Hidalgo that the buyer wants to buy. If the seller does not give that specific painting, and there is no substitute or alternative obligation, which we'll study in a short while, then the buyer will not pay. So that act of not paying is an act of rescission. In other words, hindi niya na sinunod yung obligasyon. Neither can he be compelled. Because ang sasabihin niya, Judge, pare, itong binibigay niyang painting sa akin, hindi yan yung Hidalgo gusto. It is a barrio scene. But the barrio scene I wanted was totally different from this. I remember it. So, I'm not going to pay. From the seller's, paano naman kung ang buyer ang hindi makakomply? The seller has the Hidalgo with the barrio fiesta scene that was agreed upon. He is willing to sell it for 17.75 million pesos. But the buyer came and only had 15 million pesos. Can he be compelled to sell it? O halimbawa, let's make it even closer. He came with 17.5 million pesos. Sinabi niya kay art dealer, kay Y, 17.5 million pesos, tumatangginting na pera, hawak ko na. Ang gusto mo 17.75. Tanggapin mo na. Iyan na yung pera. is seller obliged to accept it? No, he is not. So, what happens to the deal? Hindi matutuloy. At yung partido na may kasalanan at hindi natuloy is liable for damages. Kasi ganito yan. Si art dealer, kung hindi niya tinanggap yung offer ni buyer na bilhin yung painting na yon, sana naibenta niya na sa iba. Baka naibenta niya sa iba ng 18 million, 20 million. Sa halip na 17.75, di ba? So meron siyang lost opportunity. Lost opportunity is indemnifiable. A party can collect damages from the other party who did not comply. Dito nga, why am I saying this is funny? Because unless the parties agreed that in the event of rescission, in the event that one party does not comply with the other, there is a penalty, they have to go to court again. So please look at the second sentence of 1191. He may also seek rescission. Third sentence pala. He may also seek rescission even after he has chosen fulfillment if the latter should become impossible. Yung seek rescission, ang ibig sabihin niyan, pupunta ka sa korte. Yan ay uli ang mali sa ating civil code. So the power to rescind is really a judicial power. Please look at the second to the last sentence of 1191. The court shall decree the rescission claim unless there is a just cause authorizing the fixing of period. So this is the court's prerogative. When there is rescission, especially in contracts involving real estate usually. Kasi masalimuot ang real estate. Real estate involves registration and payment of taxes. That is why you cannot just have rescission by the parties. Right? Because there are legal effects in incorporeal or real rights. Real rights are those rights which refer to real property or intellectual property. So that the law has certain formalities when it comes to real rights. So when you rescind the contract to sell, usually it will really go through the courts because there is really the aspect of annotation, there's the aspect of registration in the Register of Deeds. So what happens here? When the reciprocal obligation is simple, X will buy, Y will sell, X cannot pay or Y cannot pay, there is rescission in the sense that, okay, I will not give it to you. You know, I will not pay you because you're not giving me the item you want. If I am the buyer, I will not sell the item if you are not giving me the price I want but I already have the item that you want. Diba? This is what happens almost every day in the market. Gusto mo bumili ng sitaw. Gagawin niya, isang tumpok, 5 piso. Tapos nakita ni Aling nagbebenta na yung katabi niya, 6 pesos palang benta. Sabi, hindi, 6 pesos talaga. Diba? Yan. So hindi ka bibili. Hindi niya pwede sabihin akin yung pera mo. Hindi mo rin pwede sabihin akin yung sitaw mo. There is mutual rescission. But technically they're entitled, whoever violated or gave reason for the obligation not to be fulfilled is liable for damages. Ano? Yan yung ibig sabihin ng second sentence ng 1191. Siyempre sa palengke, wala na yan. Diba? Sorry na lang kayong dalawa. Punta ka lang sa iba, baka makahanap ka pa ng sitaw rin na 6 pesos a bundle or whatever it is that is the going price. Ito uli, ladies and gentlemen, ang mahirap sa I'm sorry, we're running just bear with me please. Ang mahirap sa civil code. 1192. When there is mutual violation of the obligation, uh, the law requires that there be a determination of the first infractor so that the violation of the second infractor can be equitably tempered. Ngayon, yun ang mahirap. Kasi there are certain obligations, there are reciprocal obligations where the infraction by one party is minor compared to the infraction by the second party. Diba? So can you treat both infractions the same? Or can you treat the first infractor, no matter how minor is his or her infraction, the same as the second infractor? He just happened to be second, but has the major infraction. So the court's supposed to equitably temper. Equitably means pagpapantay-pantayin niya. I-consider niya infraction ng isa, i-consider yung infraction ng isa. But first, the court has to determine who was the first infractor. Sino yung unang hindi tumupad sa usapan in a reciprocal obligation? In many transactions, yun ang mahirap, di ba? Unless may check yan, may documentation yan. Yun ang may testigo. Yun ang mahirap. So, what does the court do if it cannot determine who is the first to have violated? Each party will bear his own damages. Like I told you, that is unfair to the infractor who's just minor. Kahit na nauna siya, minor lang naman yung kanyang infraction. We're still willing to comply. So, let's take a class picture, class presidents. I will stop presenting. The rate that we're going this morning, I don't know if we can cover everything. So I'm sorry to say, you will have to read the textbook. But ganito kasi ang pagka-divide ko ng ating topic. The later ones, which were supposed to be the second period, are really well tackled in the textbook. So if you'll bear with me, we'll go over obligations of the period and alternative obligations more completely, and then take up joint, divisible, indivisible, and obligations with the penal clause before we begin formal contracts law. I'm sorry, it's really getting more and more difficult. So let's all pause for our pictures. I don't know how it shows up. Am I supposed to change the layout to show all the tiles? I don't know if everybody, there are 52 others who are not. Yun ang problema. So class presidents, please take your attendance pa rin. Okay, so please take the picture now.
Smile po. Okay na po, thank you.
Okay, so I'll see you at 4:20. Okay? Take a rest because I am bored with myself. All get back to class. Let's try to finish as much as we can because not because it will be part of the prelims, but because it will ease the backlog we have for the next class periods. So I hope everybody has agreed na sa 14 ng gabi, simultaneous online preliminary exams, yung inyong reaction paper, yun na yung essay portion. Okay, so I already gave you grades there. I will not release the grades, but I will just include it when I report the midterm results. Okay? Generally, okay naman yung reaction papers because ang sistema karon pass-fail lang. So, wala pa naman ako nakikitang malayong-malayo na finail, no? So, for this session, so it's to your benefit. Yun ang ibig ko sabihin na isasama ko yung reaction paper nyo as the essay portion of your preliminary exams. For this session, we will take another set of attendance lists just to comply with the school's requirement for attendance. But like I said, I don't really give a grade for attendance. Bahala kayo. Inaalala nga ng kapatid ko nung nasa UP kami because my brother's just a bit younger than I. Sa UP, naalala ko, pwede kang mag-attend ng class, pwede kang mag-enroll sa class, hindi ka mag-attend. Basta pumasa ka sa exams. Because we were in engineering, so wala silang pakialam kung hindi ka mag-attend. Basta pumasa ka sa engineering being mathematical, you just pass the exams. Wala namang kahit mag-recite ka na mag-recite doon, kung bagsak ka sa exams, wala namang puntos yun. So the same thing here, bahala kayo kung hindi kayo mag-attend. You have to pass the exams because this is also a technical course. So let's try to make the best of our time. Kanina nagbibigay ako ng example, what we call and I failed, so I'll correct it now. So I will show you my lecture notes. I will give these notes also together with the last notes by tomorrow. A potestative obligation which depends on the will of the debtor. A potestative obligation is one wherein it depends on the will of one of the parties. So kanina I gave the example, di ba, na I will give you 50,000 pesos, I'll give you my car. If you'll go home to your home province, visit your mother and reconcile with her. That depends on the will of the person to whom I am giving. But the potestative obligation of a debtor, which is void under 1182, is the one where it is on the giver. So, ibahin natin example. I will give 50,000 pesos. X will give 50,000 pesos to Y. X will give 50,000 pesos to Y. If X will go home to the province and reconcile with X's mother. Baliktad yung sitwasyon ngayon, ano? So kanina yung binigay ko example is valid because it depends on the will of the person who is going to visit. Diba? Why? Dito, the obligation depends on the will of the debtor. The obliger here is X. Kaya nga importanteng you identify who are the parties when you are solving these problems. In this example, the debtor is X because he is the one who's going to give 50,000 pesos. And Y is the one who's going to receive it. With ang condition kasi ni X, he'll give 50,000 pesos to Y if X will visit his mother and reconcile with him. And suppose he doesn't want to. Suppose he doesn't care to. Suppose he doesn't really want to give 50,000 to begin with. Diba? Kaya niya ginawa yung obligation na yun. Kasi alam niyang hindi niya gagawin yun. Ayaw niya umuwi sa probinsya nila at makipag-reconcile sa kanilang nanay. Sabihin natin yun yung kwento. The reason why a potestative obligation, which depends on the debtor's will, is void is because the law does not allow impossible obligations. And an obligation which depends solely on the will of the person who says he's going to do it is a joke because he may or may not do it. Diba? So si Y, wala siyang control sa obligasyon na to because X, it depends solely on the will. It does not depend on anything that, it does not depend on any external condition. That X will win the lotto or that X will pass the bar exams or whatever. It depends solely on his will, kung gusto niya o hindi. And an obligation when the obligation depends on the debtor will, his whims, capriccio niya. Gusto niya ba o hindi niya gusto, is not a valid obligation. That is what 1182 means. However, if it depends on some third person, ito yung example. X will give his car to Y. If X will go to the US, I will underline this. I will make it red. And if the US gives him an immigrant visa. So although, kung titingnan niyo ito second example, X will give Y his only car. If X will go to the US, it depends on his will, di ba? But hindi eh. Kasi ito yung pag-uusapan natin later on. There is an alternative or a conjunctive condition. And the conjunctive condition is that if the US gives him an immigrant visa. So it depends. Kung mabigay siya ng immigrant visa, then and he goes to the US, then it's a valid obligation. Because it depends on the will of somebody else. Okay? So let us now talk about possible, impossible conditions. That's we talked about possibility, impossibility a while ago. We will now talk about express and implied condition. In many modern contracts, there is already the implied condition of fitness. In fact, the warranty over the product is not just an implied condition, it is a legal condition. It is required by law. So when Hitachi or Carrier sells an electric fan, it must be an electric fan which will not explode or burn down your house the first time you use it. Diba? Meron siyang implied warranty. That is an implied condition. Hindi yan nakalagay na, Mr. Balanag, you buy this electric fan. Ito yung ating implied condition. Ayan, nakalista. It will not burn. It will last for 2 years. If they have any problems, you give it back to us. It is already assumed to be part of the contract. So I give an example here. Just to make things simpler, hindi kumpanya. X will give his only car to his son Y, but if he fails the CPA exams, Y has to give it back. Diba? That is a resolutory condition. What if it's implied? Mag-uusap si X at si Y. Alam mo anak, Y, gusto kita mag-CPA. I am very sure that pag makatapos ka ng CPA, gaganda ang buhay mo. Para wala ka masabi na nahirapan ka ba nag-aaral ka. Kasi ako yung nag-aaral. Nahirapan ako. Commute ako, pinapawisan ako, nakasabit lang ako sa jeepney o sa bus. Ayaw ko mangyari yan sa'yo. Gusto ko maginhawa, maganda ang pag-aaral mo. Bibigyan kita ng kotse. Kasi gusto kita mag-CPA. Huwag mo akong biguin. So there's an implied condition there na kung binigo ni Y ang kanyang tatay na si X, mabalik niya yung kotse. Bigo siya eh. Di ba? Ngayon, because it is father and son, you can argue that this is just a natural obligation, di ba? An obligation which is not legally demandable, but it is something which is expected because of the trust and the love between father and son. So that when the son disappoints the father, he has a natural obligation to return the car kasi nakakahiya naman. Hindi na nga siya pumasa ng CPA tapos sa kanya pa rin yung kotse. Diba? Eh, inabangan niya ng kanyang kapatid kasi siya ang susunod na mag-aaral. Ganon. Maybe. But technically, that is an example of an implied condition. Hindi nga sinabi, ngunit alam ng anak na kailangan mag-CPA siya. Kung hindi, disappointed si papa. Kasi syempre gusto niya ibalik mo yung kotse para magamit siguro ng mga kapatid o ibenta ni tatay, di ba? Okay. But the easiest example of an implied condition is yung implied warranty of consumer goods. Likewise, when you enter into a contract of carriage with a ship under the Carriage of Goods at Sea Act, there is an implied warranty of the seaworthiness of the ship. It does not have to be stated in the contract because when you put your cargo on a ship, you are sacrificing the not only the item itself, but the profits that you expected to earn from it, or the sentimental value if it's your personal things, by putting it on a ship and putting it on the sea. The sea is a very crazy thing. Sometimes it's very peaceful. Sometimes biglang mataas ang waves. Tumba yung barko, patay lahat ng cargo niya. Di ba? So there's an implied warranty of seaworthiness in a contract of carriage by sea. It doesn't have to be stated there. It's understood. Ito pala yung buong implied. X wants his son to become a CPA, so he says, son, I want you to become a CPA and practice your profession. As an incentive to pass the exam, I'll give you my only car. So that is demandable. It is but the implied warranty is that if he doesn't pass, balik niya. Although, arguably, it's also a natural obligation. So now let's talk about conditions with a period. So you have to be able, class, to determine what is a period and what is a condition because yan yung sinasabi ko sa inyong wording ng mga kontrata. The parties agree to the following terms and conditions. So usually, meron talagang conditions, but sometimes meron rin terms. Yung terms, ito yon. A condition, an obligation with obligations with a period. Articles 1193 to 98. Yun yung ginagamit nating term na a day certain. An obligation with a period will always state a certain day, a certain time, a certain juncture in the calendar when a certain thing when the obligation should be complied with. So please, if it's expensive, that means the obligation will be only be carried out when the period starts. And it is resolutory, meaning the obligation starts immediately but ends after a certain period. Diba? So we're always talking about a day certain. Ngayon, ito ang problema mga kaibigan. Ito rin ang mahirap sa mga abogado. Pag sulat nila ng kontrata, kung minsan hindi talaga linalagay yung period of date. Ano? Sometimes it is couched in the form of certain things happening. Diba? Like when demand letter is given or when government notice is given. So halimbawa, the parties are contracting or having obligations relating to construction project. Yung pagbayad sa construction project sa gobyerno kasi, hindi yan pagkagawa. Yan ay pag nagpasa ang Commission on Audit ng clearance, na tingnan nila yung construction at yun ay pumapasa sa the terms and conditions of the contract. At doon lang pwedeng bayaran ng gobyerno yung obligasyon sa contractor. That may be said to be a condition. If you think about it, it looks like a condition. Kasi it requires the will. It relies on the will of a third party, which is the COA. But the thing is kasi, under government regulations, may period siya. So when a contractor fulfills, let's say, the cementing of a road, may takdang araw yan na magkakaroon ng inspection. Tapos may takdang araw yan na kahit na lumampas ka na doon, halimbawa, lumampas na yung panahon, wala pa rin inspection, yun yung constructive fulfillment of the obligation. Kasi kahit hindi nagkaroon ng inspection, lumampas na yung takdang panahon, binigyan ng palugit ang gobyerno para tingnan yung inspection, binigyan ng palugit ang COA para pumunta doon sa lugar at tingnan nila kung ayon ba yan sa terms ng kontrata at sa standards ng construction. Pag meron yung takdang panahon at lumampas ka doon sa takdang panahon, babayaran pa rin yung tao kasi yung contractor, umutang yan eh. Yung gumawa ng daan, umutang yan. Ginamit sa sariling pera niya, umutang siya, nagkaroon siya ng utang sa hardware, sa cement supply, sa mga tao, may obligasyon yan. So, kailangan rin siya mabayaran. So, although a government contract looks like it is a contract with a condition, it is really a contract with a period. Because although the condition is that the COA has to approve within a certain amount of time. So, ang laging pinag-uusapan dito sa obligations with the period ay time. So, ganun rin ang tawag nating contracts na ang tawag nila ay time is of the essence. Ito yung mga pamatay na mga kontrata. Time is of the essence. Please take note of this, ha? Hindi lang ako nagkukwento rito. Yung time is of the essence contracts, isa rin yung halimbawa ng obligasyon na meron talagang period. Kahit na wala nakalagay doon that the parties must pay by September 18 or parties must pay by December 25. Ngayon, halimbawa, ang time of the essence contract is where one party is in a hurry. So that kaya siya willing siguro magbayad ng mas malaki kasi nag-aapura siya. So halimbawa, a contract to construct a house. Gawin nating time is of the essence contract ito. Si X gusto si Engineer Y gumawa ng bahay. Sinabi niya, kung magawa niya yung bahay na yan in 90 days, babayaran ko kayo ng bonus na 100,000. Bakit? Bakit ito time of the essence contract? Tatanungin ni Engineer Y, Sir X, bakit ho kayo nag-aapura? Kasi lilipat na ako. Yung bahay namin na tinitira namin ngayon, may bibili na. Natanggal ko na yung mga kasangkapan ko, nakalagay ngayon sa storage. Kaya by 90 days, yun ang rin ang usapan namin ng buyer na aking lupa, lilipat na siya. So kailangan, wala na akong matitirhan ng after 90 days. Kaya lilipat ako ngayon dyan sa bahay. Kaya willing ako magbayad sa iyo ng premium. Bayaran kita ng 100,000 extra kung matapos mo yan in 90 days. O hindi mo yung matapos in 90 days, ikaw naman ang magbabayad sa akin. Ha? Kasi mag-hotel ako niyan. I-storage ko yung mga bahay, yung mga kasangkapan ko, dami kong muebles. I-storage ko yan. 1,500 pesos a month yan. So, alam niyo yung mga ngayon, mga storage facilities. You can rent a storage locker or room and fill it with your things as long as you pay the rent. One of my friends, sila yung una dyan yung storage units na yan. I already advised him na tiyakin nyo walang droga at walang patay na tao dyan na linalagay sa storage. So, may bayad yun. So, yung mga taong maraming kasangkapan o yung mga taong mayroong valuables, meron kasi storage na vault, safe, para siyang bangko, safety deposit box. Meron rin storage na kwarto lang siya, bahala ka ang nilagay mo dyan. Lahat ng mga hindi mo kailangan sa bahay, mga lumang furniture, na ayaw mo na may benta, o halimbawa, yung mga diploma, yung mga luma na, at doon may lagay, may bayad yan. So, I have to rent that. And then I have to stay in hotel while waiting. So, you will pay me. Engineer Y, after 90 days, kung hindi mo yung nagawa, kung nagawa mo yung 90 days, I will pay you 100,000 pesos price premium because time is of the essence. Kung hindi nyo yung nagawa, ikaw naman magbabayad sa akin. Bakit? Because time is of the essence. After 90 days, wala na akong titirhan. So, although wala nakalagay doon, may nakalagay na period, but when you, by the mere fact you put the term time is of the essence doon, the other party now will be alert na this is a contract where the period is very important. Whatever the other details of the contract, ang dapat mong unang tutukan kung ikaw yung obliger, ikaw yung may gagawin doon sa kontrata, para matapos yung kontrata, ay dapat bantayan mo yung period. Okay, so, again, there is suspensive resolutory. I already gave the example. Please look at 1180. And we talked already about the potestative undertaking. The potestative undertaking is one where the carrying out of the obligation depends on the will of one or the other of the parties. If it is a potestative obligation by the debtor, it is void. But if it is a potestative undertaking by the creditor, it is valid. So please take a look at 1180. I will... Oops, I was reviewing that coverage that we will have. $11.80. Pag sinabi ni X kay Y, babayaran kita kung meron akong pera. Although it depends on his on the will on the part, it is an obligation on the part of the debtor, di ba, yung magbabayad. Ang tingin ng batas diyan ay this is an obligation with a period. Okay? So what happens is that the promise to pay is one which is implicitly with a period. Ang problema rito, and this is again ang sakit ng civil code, who will determine the period? Well, actually, it's the court. So ang mangyayari dyan, kung si Y nag-aabang kung kailan na magkaroon ng pera si X at nagsawa na siya, kailangan mag-file siya ng asunto. He will have to sue in court so that the court will now say, yeah, 1182 ng Civil Code. It is when the debtor binds himself to pay when his means permit him to do so, it is one with the period. X, kailan ka ba magkakapera? Ano ba trabaho mo? Yan ang usually nangyari in cases involving BP22. BP22 is the bouncing checks law. When a person issues a check for which there are no funds, that is a violation of the BP22 and he will be held criminally liable. So ganito lang usually nangyari dyan. Meron yung mediation eh. Sasabihin ni judge, madali lang to. Gusto mo ba mapreso ka o magbayad ka ng fine? Mr. X, dahil lang pinatalbog mo yung cheque, bayaran mo na yung obligasyon. So sasabihin ni X, wala akong pera, magbabayad na lang ako kung may pera ako. Hindi yan tatanggapin ni judge. The judge will treat this as an obligation with the period. So sasabihin niya, hindi pwedeng ganyan. Si X maghihintay hanggang pumuti na ang mata niya? Hindi pwede yan. Ganito, anong trabaho mo ngayon? Sabihin ni X, taxi driver ako eh. Magkano ang boundary bawat hour? 2,000 eh. Magkano take home mo dyan? Kung suswerte yun, mga 800, kung minsan mababa na yung 500, o 500. Di syempre, kailangan niya rin ng pamilya mo, ano? Araw-araw yan. Ilang araw ka nang nagbibiyahe bawat araw? About buwan? Siguro mga, kasi may karelyebo ako, 20 araw, 20 days in the month, nagbabiyahe ako. So, kakalculate na ni judge. Siguro naman, kaya mo, 10,000 naman. O 5,000 naman. So, 5,000 a month yan, kung halimbawa, ang bouncing checks is for 100,000 for 20 months. So, sabihin ni judge, sige, hindi mo na tayo mag-hearing dito kasi pag mag-hearing tayo dito, convicted ka na, Mr. X. I will give you 1 year. Mag-hearing tayo uli, 1 year from today. Magbayad ka 5,000 a month. Tapos kung gumanda ang buhay, panahon mo, pag-ipunan mo, dagdagan mo yan. Magkita tayo uli 1 year from now. That is what 1180 means. It is the judge who sets the period. Unless the parties agree to a period. So ano ang leksyon ng 1180 sa ating mga nilalang? Pag may utang sa atin at sinabi niyang magbabayad siya pag may pera siya, tanungin mo kagad kailan ka magkakapera. Tanungin mo kagad. Then you agree on a period. Huwag na kayo maghintay sa judge. Huwag na kayo maghintay ng asunto. Meron ngayon kasing small claims. Hindi nyo kailangan abogado sa small claims case. Kung ang utang ay less than 250,000 yata. Kayo na lang yung parang sa TV. Kayo lang, dalawa, yung may utang at yung pinagkakautangan. Kayo lang doon, dalhin mo yung papeles kung saan may utang. Tapos dalhin mo yung proof na nagbayad o hindi nagbayad. Kung hindi nagbayad, walang resibo, di ba? Ganon. Kung sinasabi ng isa na hindi ako binibigyan resibo, talangin mo siya, kailangan ka ba nagbayad? Ganon. That is small claims. Hindi mo na kailangan abogado. Mas mura yon. But still you have to go to court. Going to court means mag-absent ka sa trabaho, mag-absent ka sa klase. Tapos makipagsapalaran ka na maintindihan ka ng judge. Yung mga ibang judge hindi nakakaintindi. Yun ang mahirap. So what is the lesson of 1180 again, class? When somebody binds himself to pay when his means permit him to do so, please impose a period already. Ganun ba, X? Magbabayad ka sa akin, sa utang mo sa akin 20,000 pag may pera ka. Kailan ka magkakapera? Sabihin natin 5 months from now. Pag wala pa yan 5 months, block kita. Yes, sulat natin dito sa harap ng barangay. Ganon. Do not let the courts intervene anymore. Likewise, ito pinag-usapan na natin kanina is 1182. Potestative condition which depends on the will of the debtor is void. But if it depends on the will of a third person, uh, it shall be valid. Okay, so I think I made a mistake in the numbering of the article. Uh, this portion, oops, this portion is on conditional. Conditional. So this is, we're not talking about obligations with the period. So we stop here at suspensive and resolutory. But you have to be able to determine the effects of uh, an obligation with the suspensive period and an obligation with the resolutory period. But the effects are generally the same with that of conditions. In other words, the obligation takes effect in a suspensive, when the period is suspensive, when the period which has been agreed upon occurs. And it is in the period is resolutory, the obligations occur immediately and end when a certain period ends. Okay, so X will give his only car to his son until he passes the board exams. Because after he passes the board exams, magtatrabaho siya, ang inisip ni tatay, si X, bibigyan siya ng kotse ng kumpanya. So, ganun yan. What happens if there is delay? It depends on the type of suspensive or resolutory period, but it is analogous, para hindi tayo malito, to the effects of delay in suspensive or resolutory conditions. So now we talk about alternative or facultative obligations. Ito naman isang modality na available sa parties na nagko-contract. They can agree, or it may be the situation where the debtor undertakes alternative or facultative, in other words, substitute obligations. So it may be because of the peculiarities of the person, the debtor, that he undertakes alternative obligations. So X will give Y a laptop, or he will give Y a 5G cell phone, or he will give Y a motorcycle. What does that mean? That means that the obliger, the debtor, X, has the choice on what to give. Facultative is I'll give you an example. Sorry, I have to give a good one, okay? A facultative obligation is where there is a main obligation and a substitute obligation. The obligation is still with respect to the main, but the debtor, the obliger, has the opportunity or the option to substitute it. So an example is X will give Y a laptop. However, if the laptop is not available, or instead of the laptop, he can also give a 5G phone. So that is a substitute obligation. It is the obligation to give the cell phone, which is the substitute for the laptop, is only secondary to the obligation to give the laptop. But in either alternative or facultative obligations, when the alternative or the substitute obligation is complied with instead of the main obligation, the obligation is extinguished. Now, why do we have facultative or alternative obligations? It's because of the willingness of the law to give the parties as much leeway to comply with their obligations. Kasi kung pure or conditional obligation lang yan, halimbawa, X will give Y a laptop for a certain condition, and the condition doesn't exist, then the obligation might fail. But if the law allows the parties to give an alternative or substitute obligation, and the alternative or substitute obligation is also acceptable to the person who is supposed to receive it, then it is still valid under the law. And that is why we have alternative or facultative obligations. Purely theoretical, as I told you before. Ito yung medyo mahirap-hirap. Joint and solidary obligation. A joint obligation is an obligation between parties of which is demandable from each party. So, halimbawa, yung paggagawa ng, di ba, halimbawa, gusto nyo paayos yung bahay nyo. Tumutulo ang bubong, umikislap-kislap yung kuryente kasi babasa nga, di ba? Kailangan ayusin nyo ng electrician. Tapos, hindi na nagpa-flush yung toilet. So, problema dyan, plumbing. Di ba? So, kukuha kayo ng tropa dyan. Kayong lahat, si X, si Y, at saka si Z. Si X, karpentero, latero, sa bubong siya. Si Y, electrician, so doon siya sa ilaw, sa kuryente. Si C, plumber. So doon siya sa problema na hindi nagpa-flush na yung toilet, saka nababara yung shower. Silang tatlo, kinontrata mo, magtrabaho, sabay-sabay, sa bahay mo, kasi gusto mo matapos yung trabaho, let's say, may period, let's say within 2 weeks. No? So that is a joint obligation kasi kinuha mo sila bilang team. Hindi mo naman kukunin yung isa lang kasi kahit ayusin yung bubong, may problema ka pa rin sa kuryente at saka sa plumbing. It is joint because what you can demand from each one of them is only that which he contributed. And also, si latero, karpentero, yun lang ang alam niya eh. So, iba yung kanyang rate. Iba yung kanyang kakayanan. So, gusto mo, maayos yung bubong, walang tulo, walang kalawang, ibang obligasyon nyo. Hindi mo pwedeng sabihin kay Y, siya yung electrician. Hindi ginawa ni X yung bubong. Gawin mo nga. Hindi pwede. Because although it is a joint obligation, they all have to finish fixing the house in 2 weeks' time. Si Y, hindi niya yung obligasyon ni X. Kasi wala siyang alam doon. Si X hindi niya pwedeng gawin yung kay Z. Kasi si Z, siya yung plumber, wala naman siyang alam sa plumbing. But certainly, ikaw, ako may-ari ng bahay, I want all of them to work together. And I'm willing to pay them, ano bang rate ng trabahador ngayon? Sabihin natin 750 pesos a day. So 2 linggo yan, malaki-laki halaga yan. Diba? Pag dumating yung 2 linggo at hindi ayos yung kuryente o hindi ayos yung plumbing o hindi maganda yung bubong, sabihin ko, hindi ko kayo babayaran. Tapusin muna ni X o ni Y o ni Z yung kanyang obligasyon. Ako kayo bayaran lahat kasi ang obligasyon nyo sa akin joint. Kausap ko kayo sabay-sabay. Babayaran ko kayo sabay-sabay. Kailan matapos nyo yung trabaho nyo sabay-sabay. Ganon. Solidary is when the obligation is demandable from each one. Usually ganito yan yung umuutang meron silang guarantor. The guarantor is yan ang habulin nung pinagkautangan kung hindi makabayad yung main obligor, yung debtor. So, halimbawa, sa pag-ibig, when we bought our house, we had to have a mortgage agreement, mortgage without the T, you don't pronounce the T, mortgage agreement, and then we had to look for a guarantor. So, ibig sabihin nun, kung si Attorney Balanag hindi ka makabayad para sa bahay niya, habulin nila yung guarantor. So usually gusto nila yung guarantor, meron din sariling property. Kasi kung sakaling mabulilyaso, makakakolekta sila doon sa guarantor. So ganun yun, That is a solidary obligation. But it is not strictly solidary because in a solidary obligation, you can demand from any of the obligors. A better example is iba kasi yung guarantee. There's a special contract under the law. A better example of a solidary obligation is yung jeepney na nakabangga. I also have a case like that. Nakabangga ng kotse. Wala naman namatay. Wala naman nasaktan. Tandaan lang. So ito si X, nagda-drive ng jeepney. Nabangga niya si Y. Nawasak yung kotse ni Y. Dinala ni Y yung kotse punta silang dalawa, dinala sa talyer. Ang estimate, sabihin natin, 100,000 yung repair. Si X, hindi siya may-ari ng jeepney. Ang may-ari ng jeepney si Z. Si Z, siya ang operator. Under the law, the operator is solidarily liable with his driver for any criminal or civil obligation arising from the use of the vehicle. Kung yan si driver ay hindi sumunod sa trapikong batas at nasita siya, at ang nakitang plaka ay yung plaka ng jeepney, at yung plakang jeepney na yun, pag-aari ni Z, lalabas yan sa camera o lalabas yan sa ticket na i-issue ng enforcer, ng police. Ang pupuntahan nila, yung may-ari ng plaka na yun, siyempre si Z. Si Z naman sabi niya, hindi ako nagmamaneho Ang nagmamaneho niya, yung driver ko si X. Siya habulin niyo. Hindi. Ang magbabayad, si Z. Bahala siya sa kanyang driver. Sisantihin niya kung talagang tarantado siya. Diba? That is a solidary obligation imposed by law. So, a solidary obligation, ibig sabihin si Y na nabangga ni X at meron na ngayong 100,000 kailangan na repair para mapaayos yung kanyang kotse, pwede niyang habulin si X, yung driver, pwede niyang habulin si Z. That is the effect of a solidary obligation. The obligation is demandable from any of the solidary obligors. And why do we do that? In the example is itong sa jeepney, for public policy. Kasi, yung mga jeepney drivers na yun, lalo nung unang panahon when I started out as a lawyer, yung mga drivers ng mga bus, 5 ang kanilang hawak na lisensya. Kaya pag nahuli sila sa isa, meron pa silang 4 na lisensya, makakadrive pa yung mga yan. So wala kang mahahabol sa kanila kung nakasagasa yan, kung nakabangga. Iba-ibang ID niyan. Kahit yung kumpanya, yung bus company, hindi na alam kung sino ba talaga yung taong yan. Pangalawa, bigla na mo yan mawawala yung driver. Nakabangga, halimbawa, nakabangga yung tao, yan si X. At alam niya, kasalanan niya. Bigla na lang mawawala yan. Kawawa naman si Y. So what does the law do? The law says, looks at the situation, sino nga ba naman may-ari sino ba nagpalabas ng jeep na yan? Di ba si Z? O si Z dapat magbayad. kung wala si X. In other words, si Y, yung nabangga, may alternative. Pwede niyang habulin si X kung gusto niya, at pwede niyang habulin si Y. And in fact, what happens? In my case, where I am representing Y, hinabol ko si X for criminal liability at saka si Z for civil liability kasi walang pambayad yan si driver. Wala yung pambayad. Ganyan yung style dyan. So we talk about pro rata obligation or proportionate obligation. Pro rata obligation is in joint obligations. The obligation of one creditor is proportionate to his contribution. And the proportion that you can demand from one obligee is proportionate also to his interest. So basahin nyo na lang yan. There are examples in De Leon of joint obligor and joint obligee. So it works many ways, ano? There are many obligees, and can they demand the obligation from any of the obligors? And can any of the obligors demand payment after complying with the obligation from any of the obligees? Diba? So that is when we discuss pro rata obligation and proportionate obligation. So let's look at the civil code. I'm really sorry, class. I'm getting bored with myself. I'm sure you're also bored, Steve. But ang suggestion ko is if you follow the lecture and you look at the provisions and then you read the book, then hopefully this exercise will allow you to understand what is being spoken about. So I am showing to you now alternative obligations. You know? So I just like you to note Article 1200. Article 1201. In fact, the articles where I have highlighted 1202, 1203, and 1204. Ito rin ngayon ang mahirap nitong 1201. We're talking about alternative or substitute obligations. And the right of choice belongs to the debtor. No? Unless as provided in Article 1200, it is expressly granted to the creditor. Mahirap kasi yung the choice is given to the creditor because really what's happening is that it's really more of a condition. You know? Because it is the creditor who will decide which of the prestations, which of the things that the obliger says he will do will be done by the debtor. The term we use when the right of choice belongs to the creditor is that the obligation is more onerous. You know? When the right of choice in an alternative or substitute obligation, facultative obligation, is expressly granted to the creditor, it becomes more onerous. It becomes more burdensome. Because now the debtor has no control over what of the obligations he had intended to do he will be able to carry out. Because usually kasi the alternatives are granted. So, di ba sinabi ko sa inyo, the law wants the obligation to be carried out. So, kung hindi mo kaya yung A, baka naman kaya mo yung B. Pag hindi mo kaya yung B, baka naman kaya yung C. So, sige, go ahead and agree to that. Basta gawin mo yan, Mr. Debtor. Ha? Tumupad ka sa usapan. That is what the law wants to happen. Para hindi naman yung A lang, tapos pupunta kayo sa korte dahil hindi nagawa yung A. Diba? So the law allows alternative obligation so that the obligation can be complied with, the parties will be happy. But usually, the choice of the obligation to be done is left to the debtor kasi siya yung may kakayanan. He is the one who's able to gauge, ano may kaya kong gawin dito? Kasi kung ibibigay ko yung, kanina yung example na binigay ko, kung ibibigay ko yung scooter, baka kailangan ko pa yung scooter So, huwag sana muna yung scooter. Ang pinakamadali, bigay ko yung laptop. Bigay ko na lang yung laptop. So, ganun kasi yung calculus, ganun yung pinag-iisip ng debtor, okay lang yun. Kasi ang gusto ng batas, magawa yung obligasyon. Di ba? Si creditor ay mabayaran in some form, whether it's a laptop or cellphone or the scooter. Di ba yung example natin binigay kanina? The alternative obligation is to give a laptop or a cellphone or scooter. But it is the debtor who is allowed to make the choice kasi yun ang iniisip niya. Teka na, wag mo na yung cellphone. Hindi ko pa nabili yan. Baka mahal na yan. Baka tumaas na ngayon. Yung scooter, meron akong scooter. Usually ibibigay ko, kaso baka gamitin ko pa. So, the law allows him to choose so that he can comply. But when the right to choose is given to the creditor, it becomes more onerous kasi ngayon wala siyang control kung ano ibibigay niya. Kung pinili ni creditor yung motorsiklo in payment of the obligation, at ginagamit niya pa, siya naman maagrabyado, di ba? Wala na siyang sasakyan. But had he been allowed another alternative, and had he been allowed to choose, he could have complied with the obligation, tapos na sana ang usapan. Okay? Ngayon ang problema sa 1201, the choice shall have the effect until it has been communicated. Ito mahirap sa civil code. Hindi lang naisip na ang communication ngayong 2022 ay through text, through social media, through applications, APKs, you can even convey it through agents, you can convey it through friends. So, what is the time that has been communicated? And this is the lesson for all of us, and that is why we are studying contracts under Attorney Balanag. Wag na kayo mag-depend sa mga pangyayaring mahirap i-determine. When was it communicated? Yan ang problema sa 1201. Ilagay nyo na sa kontrata. Explicitly. Now, if it has not been determined yet, kasi pipili pa lang si debtor, ilagay nyo ran explicitly that the debtor X has to communicate his choice, whether it is laptop or cellphone or motorcycle on or before September 30, 2022, halimbawa. Di ba? Or it shall be communicated by email only at email address given. Such that if it is not received by September 30, the debtor X is presumed to be in delay and therefore is liable for damages. Yan ang mahirap dito sa 1201. Siguro noong unang panahon, okay lang yan kasi there's only one way of communicating, by letter, through an agent, or verbally. Ngayon hindi may social media, may Viber, may Messenger, may Discord, may ano yung ginagamit ko sa Bali, gusto nila sa Indonesia, WhatsApp. I only had WhatsApp because of my vacation in Bali. After that, I removed it. Kasi Zuckerberg bought WhatsApp and I didn't like his privacy policy. Okay. The others are common sense. So, just read them. Itong 1205 is when the choice is given to the creditor. So, like I told you, it's onerous. That's why there's so many conditions. Tingnan nyo. The law is stricter when the choice is given to the creditor because really it's more burdensome for the debtors. Kaya just read through the conditions and hopefully it will never apply to you when you practice. In practice kasi, yung facultative and alternative, these are just really theoretical terms, ano? The important thing is that, remember, the law gives the parties full power to carry out an obligation para matapos na yung obligasyon at magawa whatever it has to be done between the parties. That's the only thing you really have to remember. So, joint and solidary obligations, definition. Ito ang importante sa 1207. There's only solidarity when it is explicitly provided or when the nature of the obligation requires solidarity. The nature of the obligation means it is in the law. Yun yung binigay ko yung example sa inyo, jeepney driver. Or, in a limited case, not very exact, yung guarantor. Kasi hindi mo naman mahuli yung guarantor. The guarantor is subsidiary liability. It is not solidary liability. The best example really is the jeepney. The law presumes solidarity in certain obligations, especially in the corporate code. When a corporation commits fraud, di ba? Ang dami ngayon tech scam. Ang dami mga kumpanya na nanloloko, magre-recruit ng tao, tapos kukuha ng pera, tapos wala pala. Yung liability na yan ng korporasyon, a corporation is a legal being. A corporation is a legal being, but it cannot be held criminally liable. At saka syempre, pag naghahabol ka ng pera, you're really going after the people behind the corporation. Diba? So, you want to know who are the people behind the corporation. And under the law, under the corporation code, the people behind the corporation are the members of the board. Kaya mahirap yung maging member of ng board ng isang corporation or board of trustees. I'm a board of trustees of several non-profits, so mahirap yun. That's a delicate obligation. Kasi when something is wrong with the corporation, especially when it is criminal liability, the liability is solidary. Ibig sabihin, the law can punish all of you, even if only one of you committed the fraud. The mere fact that you went together with others in a corporation at loko-loko pala yung iba, wala nang pakialam yung kumpanya sa kung ikaw nga yung gumawa. So there are certain frauds committed by corporations for which the entire corporation, the members of the corporation, the members of the board are held liable solidarily. Kasi ang inisip nila, kayo naman yung nagtayo ng korporasyon. Kayo yung nagsabi na kaya nyo to, ganitong gagawin nyo. Kayo yung may assets. Kayo, hindi kayo isa sa bawat sa inyo habulin. But what happens after the imposition of solidary liability? So we have here 4 persons, A, B, C, and D. They are all under a solidary obligation. In other words, si X can demand an obligation, the full obligation, let's say to pay 1 million pesos. Whatever their prestation. Prestation means whatever the obligation, the undertaking that they agreed upon, whether it's to buy land or to buy a painting, whatever. Basta, 1 million yan. At hindi tumupad. So si X, ang kilala niya lang talaga si C. Hindi niya kilala si A, B, at D. Si C, kapitbahay niya. Hinabol niya si C. Pare, bulilyaso yung obligation niya dyan. You owe me 1 million. Please give it to me. Under the law, because it's a solidary obligation, it expressly was stated in the contract, or the nature of the obligation was solidarity was required by the law. Wala akong choice si C kundi magbayad. Bayad siya 1 million. What happens now? C can collect from A, B, and D. Because A, B, and D are subsidiarily liable now to C. So we talk about subsidiary liability of solidary creditors. So please take a look at the effect of solidarity okay, so ito yung characteristics ng solidarity, 1208. Well, 1209 is common sense. 1210, please note that the indivisibility, which we will take up, does not mean solidarity. Nor does the solidarity mean indivisibility. We'll try to sift through that later. Twelve. Of course, 1211, which is what we are talking about. You may have solidary creditors and solidary debtors, but the relationship between themselves and with the debtors may be different, depending on their agreement. So, ito yung sinasabi ko. A debtor may pay any one of the solidary creditors unless somebody already demanded it first. Let's not go over 1215 muna. I'll explain that later. The creditor may proceed against 1216. Please note that. Solidarity means that the creditor can go against one or all or some of them. Okay? So, halimbawa, binaya A, B, and C, D, si C, hindi niya nabayaran yung 1 million, kalahating million lang, I can now go against B and until the obligation is satisfied. But when anybody pays, syempre tapos na, no? Ito yung sinasabi kong subsidiary liability. The debtor who paid can collect from his co-debtors. And payment by a solidary debtors is possible as long as it has not prescribed or has become illegal. Explain ko to. Prescription is the granting of a period. So there are certain obligations by law which prescribe. So it is stated in the Civil Code that under the statute of frauds that certain legal documents have to be in writing, within a certain period, or committed to writing in a certain period. Otherwise, it becomes unenforceable. In other words, it is valid between the parties, but it cannot be enforced in court. Prescription means that a certain time period for the obligation has already passed. Now, why do we have prescription? We have prescription because it is an act of equity. Because the law does not want obligations to be running on forever. So, although prescription is not an obligation with the period. Prescription is a period imposed by law or imposed by the nature of the obligation. Another term we have to study in 1219 is remission. A, B, C, and D. May utang sa akin yung 1 million. Si C kasi, siya kapitbahay ko. Mabait tao yan. So sinabi ko kay C, alam mo pare, under the law, nag-aaral ako kay Attorney Balanag, you are solidary obligers to me. I can demand the whole 1 million from you. Kaibigan kita, alam ko, kapos ka ngayon kasi magkakalit yung mga anak mo. Gusto pa nila mag-aaral sa Ateneo, isang taon sa Ateneo, kalahating milyon. Sige, bayaran mo lang ako ng 500. Abulin ko na lang yung iba. Pwede ba yan? Pwede. It's under 1219, the remission made by the creditor, which affects only one of the debtors, does not release the others from their account. So, the other debtors are still can be collected. Hindi na pwede sabihin, binigyan mo ng tawad si C. Wala na, tapos na, ubos na. Tapos na yung obligasyon kasi tawad na yun. Hindi. Ang tawad na yun kay C lamang. The 750,000, because binigyan ko ng tawad si C na 250, I can still collect. So the others are common sense provisions with respect to fortuitous event, a delay, the application of which is almost the same as with individual debtors. Okay. The thing to remember about solidary obligers is that they cannot do anything to the prejudice of their co-obligors. So if this obligation consists of the holding of a thing or a property, they cannot destroy or damage the property, even if they're allowed to use it, to the detriment of their co-obligers or their obligers or co-debtors who do not have access to the property. Okay, so 1221 is really, and 1222 are really just about that. Divisible and indivisible obligations. Sorry, we really have to there are obligations which have to be carried out, although they seem to be composed of several parts. So, 1223 speaks of the divisibility or indivisibility of things. So chapter 2 of this title is with regards to kinds and natures of obligations. So what 1223 talks about is that a thing which is divisible or indivisible. Artwork is not divisible. Kwento ko sa inyo. Alam niyo yung Spolarium? It is that magnificent painting by Juan Luna. He won a royal an art award in Spain, in Paris rather, when he in Spain when he painted that. The Spolarium is a painting of gladiators after the fight. After the fight, the gladiators' bodies, those who were slain or wounded, are taken from up in the arena down to the, alam niyo sa ilalim kasi ng Colosseum where the gladiator fights are held, there are lots of cells. May cell dyan where they keep the gladiators, there are cells where they keep the weapons, there are cells where they keep the guards, there are cells where they bring the bodies to prepare them for burial or for treatment. So may parang first aid, tapos meron din yung mga patay. The Spolarium is a very depressing painting about gladiators dead gladiators, blooded and everything that, being taken away from the arena upstairs down to where their corpses will be deposited. It is very metaphorical kasi yung image ng gladiator na patay para yung image ng Pilipinas nung panahon ng mga Kastila, na ginamit lang yung mga Kastila, Sawaan nila, nung patay na, hinagis na lang. Yun ang metaphor sa spolarium. What is amazing about the spolarium, more than its metaphorical meaning, its nationalistic meaning for us, is that it is painted larger than life size. Larger than life size. Kung makita niyo yung spolarium, magmamangha kayo. Because it is bigger than you. The spolarium is about 11 feet high. The entire painting. It is a gigantic painting. I don't know how one Luna, who is probably not even 5 feet tall, could have painted that. He was such a genius to have painted it. Now, why do I say a painting is indivisible? The spolarium was donated by Spain during the time of Franco in the 1930s. Franco was a dictator, just like Marcos was, during the 1930s in Spain. As a gesture of goodwill, sabi niya, yung spolarium na yan na nandiyan dito sa ating Prado Museum, bigay na natin sa Pilipinas, parang pakitang magandang tao ng Spain. A gift of Spain to one of its former colonies. Napakalaki ng painting, hindi na naman pagkasya sa barko. Alam niyo yung mga barko nun? Siyempre, hindi naman yung mga tulad ngayon na lalaking mga barko. It has to be put in a box. And the box has to fit in the hold of the ship. And the hold of the ship has a hole, and the hole is only so big. So a painting which is 11 feet by about 20 feet, hindi nila ba pagkakasya? Baka masira pa lalo. Yeah, so ang ginawa ng mga Kastila, they cut it up into 3 pieces. In fact, when you look at the spolarium today, you can see where the Filipinos who received the painting and had to sew it up together again, you can see where the seam is, although they were very good in restoring it. Is the spolarium a divisible item? Such that if I want to buy the spolarium, assuming it's for sale, at the spolarium is, let's say, worth 150 million pesos, although I doubt it, it's probably worth more. Can I just buy 1/3? The third that shows the gladiator in the center for 50,000, 50 million? Is it? That is an indivisible thing which is not susceptible of a divisible delivery. Now, you cannot ask to buy the spolarium, which is indivisible, in parts. You know? But there are also indivisible obligations. Unfortunately, you'll have to look at De Leon for a good example of that. As to the divisible and indivisible obligation, because I want to finish obligations with the penal clause so we can talk about the prelims. So now we go to obligations with the penal clause. Now, having mentioned De Leon and De Leon, I hope that by this time, meron kayong access sa libro kasi I really tell you frankly, when we were in UP Law, we did not read De Leon because it was so simplistic. But De Leon and De Leon, it has been amended by, I think, the daughter. Is a vastly improved product, and it seems to be, at least to my estimation, 95% accurate. No? So there are some illustrations there that are not accurate, but when it comes to the divisible and the divisible, just look at it. Also the examples of obligations with the penal clause. Ang importante lang dito so I hope you have access to De Leon because it will give you the parts which I did not dwell on. The parts I did not dwell on are purely theoretical. This is what I was telling you earlier. Pag gumawa kayo ng kontrata o paggawa kayo ng kontrata, tiyakin nyo na mayroong penal clause. May penalty kung sakaling hindi sumagot, hindi tumupad, may penal for each party, because the contract has to be fair to each party. And because when you have a penal clause, that substitutes for having to go to court and imposing a penalty. ito yung sinasabi ko, if you look at 1227, 1226, the penalty shall substitute for indemnity for damages and payment of interest in non-compliance. It is payable if the obliger refuses to pay the penalty. Damages are payable if the penalty is not paid for if there's fraud. So fraud may not be the subject of damages because fraud has to be determined by a judge. So you cannot say there that in case of fraud, the other party shall pay a penalty of, let's say, 2 million. You cannot say that because fraud is a legal issue which must be determined by a judge. But otherwise, you can have the other party pay for any penalty. You can impose a penalty for any failure in the contract. The problem is that you must be good in estimating your probable damages and interest because when you have a penal clause, yun ang tutuparin. You cannot say na, Judge, ito ang linagay namin penalty dito na 1 million. Masyadong maliit kasi actually nalugi sa aming kumpanya 15 million eh. Yun na lang habulin namin daya. Pag meron kang penal clause, yan ang i-impose. That is the penalty is what takes place instead of demand for damages or interest. So kailangan magaling ka mag-estimate. Kung sakaling hindi tumupad itong kakontrata ko rito, ano bang malulugi sa akin? Ilagay na natin yung penalty para yan ang babayaran niya. Kasi kung hindi ako magaling mag-estimate ng penalty, ano yung lugi ko? At mas malaki yung lugi ko kaysa doon sa penalty na impose ko, hindi ko na mahabol yan. Except for fraud. Except when the case can be complained of in court. But even if the case can be complained of in court, except for fraud, and unless you did not have a provision for delay, the penal clause will be the one imposed. So it better be well written. That is also what 1227 says. This is the instances where the penalty may be imposed. In 1228 says that there is hindi na kayo maghihiring kung magkano talaga. If you agree na penalty of 1 million, actually ang lugi mo lang 500,000. You don't have to say na, sasabihin ng kabila, bakit? You show me nga ano talaga lugi mo rito sa hindi ako nakabayad, hindi ako nakatupad sa obligation. You show me proof of actual damage. It's not necessary. 1228. Proof of actual damages is not necessary because the penal clause is what the parties agreed on. So yung kabila dapat also na-estimate rin nila ano bang mangyayari sa akin kung hindi ako tumupad. So kailangan tumupad ako kasi patay ako rito. Ganon, ano? The only time the penal penalty shall be interfered with is in times of partial or irregular compliance. So kung mayroong partial compliance, o may compliance kung medyo sablay ng konti, the judge kasi a court is a court of justice and equity. Justice is what is written in the law. Ano? Kung sinabi ng law, may penalty, yan ang bayaran mo sa penal clause. Ano? But if the party was, yun yung pinag-usapan ko kanina, minor infraction lang naman or irregular lang ng konti yung kanyang pag-comply sa obligation. Kung na-comply niya hindi naman fully, ngunit acceptable na sana. The court is now transformed from a court of justice to a court of equity. Equity means, let us be fair. Ito nga nakalagay sa batas. Ngunit, alam mo, yung compliance naman ni debtor 85%. So, penalty siguro 15% na lang ang dapat i-impose sa kanya. And, ang maganda, kung yung penal clause mo ay null, Usually kasi when there is one part of the contract is null, all of the entire contract is null, no? For lalo na if it has to do with obligations. If the obligation to do is null, then there is no obligation at all. Okay. That's why if the principal obligation is void, the penal clause is only subsidiary. It is independent but subsidiary, but it really depends on the principal obligation. That is the coverage of our topic for today. Up to today. But the exam shall only cover alternative. That's why I'll just let you read after alternative. Ano? Yung joint, yung divisible, penal clause, you just read that. I will go over those things again for things that are important when we consider chapter 4 next time. And so that will bring us to contracts. Ito na yung mahirap-hirap. Okay, so extinguishment of obligations is important for us to be able to understand contract law, which is really what this course is all about. Now, I'd like you to look at your Dillon. If you'll notice, there are exercises after each chapter. And there are problems. I will give you an example on page 30 of the 2021 12th edition of a problem involving extra-contractual obligations. Number 1, no? It says, I'm sorry I cannot screenshot it. I respect the intellectual property rights of the author, but this is of course for instruction and it is covered under fair use. But I do not have any device for which I can show you the example. So the example is that X sees a child in the shopping mall. Ano? So naawa siya doon sa bata. Kasi the child strayed from the mother. Naawa siya sa bata, so pinakain niya muna. Yes, kinuha niya yung bata, pinatigil niya pang iyak. Sabi niya, okay lang, hanapin natin yung nanay mo. Nalata niya nagugutom. So pinakain niya, yung mall sa Estancia Mall. Ano yung Estancia Mall niya sa Kapitolyo? Social masyado yan. Lahat mga kainan dyan, mamahalin. Sa lahat ba naman ng lugar na kailangan niya pakainin yung bata, naisip niya pakainin yung bata doon sa Estancia. So pumunta siya sa Armas Restaurant. By the way, my mom's middle name was, when she was still single, was Armas. It's a Spanish surname. My grandmother had Spanish blood. But the Armas restaurant is not owned by us. It is Alba pala. Hindi pala Armas. Alba restaurant. It's a Spanish restaurant. Doon niya pinakain yung bata, ay mahal. Ganahan, kumain ng mga tapas, kumain ng mga morcon, mga kung ano-ano, mamahalin na pagkain. Umabot yung bill ng 1,200 pesos. Hindi kumain si X. Pinakain niya lang yung bata. Yung bata yung ganahan. Nag-order ng mahal na soft drink doon. When you go to an expensive restaurant, never order soft drink. Just order juice or order water because it's better to pay more for juice than to pay 150 pesos for soft drinks. Soft drinks is just sugar, di ba? Never order the iced tea either. Okay. 1,200 pesos na gastos niya. Can he collect that from the mother? So I'm not concerned with the answer. Ano? The thing is, you should be able to examine the facts of the case. So, kailangan tingnan mo muna yan. Ano ba yung sitwasyon? Ayan si X. Tapos may bata. Tapos may nanay. Tapos nawala siya. Nawala. Yun ang importante yun sa kwento. Nawala siya. So kinukup muna siya ni X. Pag nakita mo yung sitwasyon na yan, kahit hindi mo alam kung anong chapter yan ng libro ni De Leon, isipin mo kaagad, walang relasyon si X dun sa nanay. Hindi naman siya tatay, hindi naman siya taga-alaga, hindi naman siya may-ari ng mall, di ba? Hindi naman siya security guard. Basta tao lang siya na nandoon sa mall. Nakita niya yung bata na wala. Naawa siya, pinakain niya. That will already tell you, this is one of those cases of unjust enrichment. Diba? Kasi, napakain mo yung bata, alagaan mo siya, sabihin na natin, alagaan siya kasi kumain siya mabuti. When you look at a problem like that and you already see the situation, and you have studied what we have been taking up until this point in time before the prelims, meron ka ng clue kaagad kung saan mo anong prinsipyo ng batas na pinag-aralan natin ang i-apply mo at saan mo mahahanap ngayon yung obligasyon na tiyak tatanungin ni Attorney Balanag na tinanong ni De Leon. Ano? So, I want you to develop the mentality of being able to look at a certain set of facts. When you look at the set of facts, you can ask probably for clarificatory questions, but usually the person who gives the sets of facts, yun lang ang facts niya. Bahala na kayong mag-apply ng prinsipyo ng batas na palagay mo ay tutugon doon sa tanong. Now, can you presume certain facts or can you presume certain relationships or certain principles? You can, but you have to state it. Ano? So, pwede mo, you can, pagsagot mo sa situation na ganito na tinatanong ni De Leon and De Leon sa kanyang libro, sa page 30, pwede you can answer it assuming that X is not the owner of the mall. Kasi kung owner siya ng mall, iba yung obligasyon niya. Diba? Assuming that he is also not the security guard or any way related to the child and does not know the mother, then this is a situation where a third party unknown to X has benefited because the person over whom he has custody was taken care of. And this is the application of ganun sagot mo, di ba? Tama yun. Sabihin natin. Na? So I want you to look at the sample problems of De Leon for each of the chapters that we have taken up. That will give you an orient. You don't have to study all of them. When you look at it, you can see naman kung ano yung magandang example. Kasi may sagot sa likod. Ano? So tingnan niyo yung sagot sa likod, i-apply niyo yung prinsipyo, at doon yung makikita paano sumagot sa mga ganito. So I'll already tell you, I will not take a question from De Leon. But I will follow the same format. I give you a set of facts. I make sure that those set of facts will only apply to one particular issue that we have taken up. So I will not ask you a situation which requires knowing alternative obligations or joint obligations or indivisible obligations because we did not take it up. Okay? So it will already give you a clue. If I give you a problem wherein there is a condition, then you know that somehow or the other, obligations with the condition, the rules applying to obligations with the condition will apply in this particular problem. If I give a term or a period, then it is obligations with the period. And why do we have to be able to have this discernment? Why do we have to have this frame of mind? It's because it makes the problem solving faster. Kasi sasabihin ko na sa inyo mga kaibigan ko, the problem solving questions will be under time pressure. So please don't take your sweet time. If this is your first time to read about let's say conditional obligations, if this is your first time to read about obligations with the period, babasahin nyo pa lang para maintindihan yung problema, ay nako, magubusan kayo ng oras. Okay? Kahit kung kayo yung mag-aabang pa na yung pinakamagaling sa klase nyo ang sasagot, tapos kokopyahin nyo lang yung sagot, baka mahirapan yung pinakamagaling sa klase at maubusan kayo ng panahon. Kung kayo yung nag-study group at nagdi-discussion pa kayo kung ano ang dapat na tanong, pero ang pinakamagandang sa tanong, maubusan kayo ng panahon. Okay? So I already give you that warning. The prelims are any examination is the worst time to study a subject for the first time. So, kung mahalata nyo, I did not take up all of the provisions. Because some of the provisions are commonsensical. So you just apply them without really having to know the exact provision. I will not ask you, hindi naman ito law school, to cite a exact provision. Yes, but if you do, that's in your favor. Ibig sabihin, although you're under pressure, you're able not only to understand the facts of the case, you're not only able to already localize kung ano ba dito sa maraming mga sections nito na pinag-aralan namin at Attorney Balanag. Condonation, conditions, obligations to the period, then pure, tsaka types of obligations, sources of obligations. Once you're able to localize that, it makes it easier to answer the question if it's an open book exam. Baka kasi may hantulad mo yan kung ano yung example na binigay sa libro. And if you have more time, and you're able to cite na, sir, ano ito this is an obligation arising from contract under Article 1157. Wow! Icing on the cake yan. That gives your correct answer the color of authority kasi na-cite mo pa yung provision. But it's not necessary. Yan yung mga mahabol ng Latin honors or ng Dean's List honors. Ganon. Yan ang style doon. But as long as you answer the question, understanding the facts of the case and applying and using the applicable law, correct na yung answer niyo. Okay? Ganyan ang problem solving. The entire exam is not problem solving, by the way. I have not done it yet, but I assure you, I will not pigeonhole you. Kasi mayroon magaling sa problem solving, mayroon magaling sa true or false, mayroon magaling sa multiple choice. So I will, and all of these types of questions, ang pakay ko dito, of course, makita ko may natutunan kayo. Kasi ako lang nagsalita rito, hindi ko alam kung meron kayo naintindihan. Pangalawa, ang pakay ko rito, masanay kayo sa mga how to take exams. Para pagdating nyo sa susunod yung kurso o kung pagdarating nyo sa board exams, yakang-yakan nyo na yan. Diba? Kasi alam nyo na yung style. Multiple choice, true or false, fill in the blanks, alam nyo na lahat mga yan. Komportable kayo sa style ng pagtanong. Hindi nyo alam yung sagot. Malalaman nyo pala sagot pag nakita nyo yung tanong at i-apply nyo yung alam nyo. The advantage here, ladies and gentlemen, is that because we are online, necessarily it's open books. Kaya sinabi sa inyo, yung tanong ko, malamang hindi yan manggagaling kay De Leon, at kahit galing yan kay De Leon, maubusan ng panahon nyo kahahanap ng tamang tanong at yung tamang sagot sa likod. Binibigay ko lang yung ehemplo yung halimbawa ng De Leon upang meron kayong pag-reviewhan. But huwag niyong reviewin lahat, mababaliw kayo. Okay. I have exceeded my time. I apologize, but I will transmit the questions by siguro Google Doc. I'll decide. But definitely I'll tell you where to get it and at what time, and what time it is due. So tulad ng reaction paper, any 1 second after the time it is due, forget about it, okay? So I'm sorry to take up more time than I planned. I just wanted to make our next session easier. I hope everybody has a restful day. I will send all of these materials hopefully by tomorrow, but definitely before the exams, well before the exams, so that you can prepare. And good luck to you all. I hope everybody does well because I want to be proud of you. I want to know all of you by name so that when you pass the board exam, sabihin ko, estudyante ko yan. Magaling talaga yan. Okay? So, goodbye.